Welcome everyone to another broadcast of AML Gray Matters. Today's date is 8th of March, 2023, and I'm your host, Kimberly Smith. I want to welcome all of our listeners from all over the world and a special warm welcome to Silo Compliance System users. Today's topic is the FATF Mutual Evaluation Methodology changes, and our guest is Elisabeth Lees of Claritas Legal and Claritas Compliance in the Cayman Islands. But before we begin, this is a reminder that today's broadcast is not legal advice. We always aim to conclude after 1 hour. And given the number of registrants, almost 800 today, we are unable to respond to questions posted. However, I do encourage you to post questions you have, and I will review them with Elisabeth after the broadcast, and we'll work together to provide answers to those via a LinkedIn post and in an article that will be emailed to all registrants. And for those that need certificates, those will be auto-generated to live attendees only, and you will get that email 1 hour after the broadcast ends. Also, there are 5 handouts today, so please take a moment to download those when you get a chance if you haven't already. Now, today we're privileged to have joining us Elisabeth Lees of Claritas Legal in the Cayman Islands. Claritas provides AML regulatory advice to Cayman and BVI entities. They also assist law enforcement agencies, supervisors, and governments in any jurisdiction in relation to FATF evaluations and findings. Elisabeth's background includes serving as National Coordinator to the Cayman Islands AML Steering Group from 2019 to January 2022. As National Coordinator, Elisabeth led the response to the FATF 4th round mutual evaluation. Her efforts resulted in Cayman meeting 61 of 63 recommended actions. And for her hard work, she was awarded a badge and certificate of honor for legal services rendered to the Cayman Islands government. Congratulations, Elisabeth, and well done.
Thank you, Kimberly, and thank you very much for having me here today.
Oh, it's great to have you. Now, Elisabeth, in preparation for today, I had to familiarize myself with the mutual evaluation methodology, and quite a task, I might add. I was not very familiar with it before. Now, in particular, the process of a country performing their national risk assessment really stood out to me. And for those of you listening in, I'm showing a slide of all the sectors and agencies of a country that are involved with providing information that is used to draft a national risk assessment. And this includes the public and private sectors, a country's financial intelligence unit to report on SARS, law enforcement agencies, the court system, and of course, the regulators or supervisors. Now, I read that there were 8 working groups working on the national risk assessment in Cayman, and that's a lot of cats to herd. Now, Elisabeth, were you part of that process?
Yes, I was part of the national risk assessment process, and the final result, the National Risk Assessment 2021, has been published, and I would encourage everyone to review that document if you haven't already. You talked about the different working groups, Kimberly. As most people know, the National Risk Assessment first of all looks at threats. So there's a working group looking specifically at threats and what threats the jurisdiction is facing, and then at vulnerabilities. And in relation to vulnerabilities, we go through all the different sectors and review what areas they may be particularly vulnerable to. For example, trust and company service providers, lawyers, accountants, as well as securities, the securities sector. The National Risk Assessment looks at money laundering, terrorist financing, and proliferation financing that we'll talk about a little bit later. And I think one of the things that's important about the National Risk Assessment is for regulated entities not only to look at their own sector, but also to look at the other sectors who may be part of their client base, and therefore that risk becomes relevant to them.
Now, I understand too that there are, 23 countries on the FATF gray list. Now, these include the Panama, the UAE, Jamaica, Jordan, South Africa, Barbados, Turkey, and the Philippines. And 2 countries were recently removed from the gray list, and those are Cambodia and Morocco. Now, using Cayman as my case study, I was looking at the timeline and was surprised at the length of time between the on-site visit in December 2017, the report from that visit that was published in April 2019, over a year, and then for Cayman to officially be put on the gray list, almost 2 years. Can you explain why that would be?
Yes. So the on-site visit, as you say, took place in December as you can imagine, that process takes about 2 weeks, and there's many meetings with all the different agencies, some of whom you just referred to in relation to the National Risk Assessment, the different law enforcement agencies, the different supervisors, as well as representatives from the private sector. So having compiled all that information shortly before Christmas, as it was in our case, they will then go away, the assessors, and provide their first draft. The assessors will come from different jurisdictions, and they will work together on different areas to produce one overall report. So the first draft will be shared, and then there will be 2 further versions of the report as comments are exchanged back and forth. After that, there'll be a plenary, in this case, the FATF plenary of November 2018, where the final version of the report is discussed and debated and ultimately approved. In some cases, and in our case, that report will then also go to the FATF, who met in February of 2019, and the report was then approved in its final version and published in March of that year. After that, because of the grades that Cayman received, particularly in relation to effectiveness, Cayman was placed into an observation period. The observation period is usually 1 year. It was slightly longer in Cayman's case and in the case of other jurisdictions at that time, because of course that was when the COVID pandemic commenced. Following the observation period, the country then reports to the joint group, who reports to the FATF plenary on progress made by the jurisdiction. So when we received our report, we had 63 recommended actions that needed to be addressed. We addressed those as best as we were possibly able to, and we reported on those to the joint group in the January, and then they reported to FATF and decided that we'd met 60 of those recommended actions, so they were no longer subject to scrutiny, but 3 remained, and those 3 were the items that were then placed on the grey list to be addressed.
Okay, thank you for explaining that. All right, and Elisabeth, again, thank you for being here. I'm going to let you take it from here with your presentation. If I have any particular questions, I will ask them. And again, for our live audience, I remind you to please also post your questions, but we won't be able to read through them due to the audience size, but we will attempt to answer all questions in a follow-up email and on LinkedIn. So Elisabeth, take it from here.
Thanks so much. Thanks again, Kimberly, for having me. And I know that your Grey Matters webinar is becoming increasingly popular, and I know it's very informative because I've listened to it several times myself. So I'm hoping I can maintain your high standards today. So
I'm sure you will.
Just a brief overview.
You might even raise the bar, Elisabeth.
Just a brief overview of what I want to talk about, a brief introduction for anyone who may not be as familiar with FATF. I know we've just spoken a little bit about it in our preliminary words, an overview of the 5th round, and then a more specific focus on 4 areas, which are risk and context, beneficial ownership, proliferation financing, and asset recovery, and then a few words in conclusion. And I hope we'll be interactive to some extent in that we have a few poll questions for the audience. So perhaps we could start with the first of those. When does the 5th round commence for the Caribbean Financial Action Task Force? If people could choose one of the 3 options, is it 2025, 2026, or 2027?
Okay, I see that the poll is collecting responses now. So we'll give it just about 10 more seconds and then close that down. All right. Tom, if you want to go ahead and close it, I can. Fantastic, and share it. Are you sharing the poll results?
I see the poll results, and
okay,
I see that
fantastic.
63% have correctly identified that it's 2025.
Okay.
So the Financial Action Task Force have announced that they will commence their 5th round reviews in 2024, and we expect the FSRBs, which is the FATF style regional bodies, including CFATF, to commence the following year, which is 2025. Now, this is a difficult period for countries, because even if you were to be given a year for an on-site visit, of course, what the assessors are collecting is information, statistics, and case studies from the previous period, which usually covers 4 years. So once you have a date for your evaluation, you're in fact looking at 4 previous years of information to be provided. So that's the start of the round, the 5th round, and we'll speak a little bit more about what that means and the Cayman Islands in due course. So just to remind ourselves that the Financial Action Task Force leads global action to tackle money laundering, terrorist financing, and proliferation financing. And it promotes global standards to mitigate risks and assesses whether countries are taking effective action. So we just spoke about the Cayman Islands on-site visit and assessors coming from different countries and producing a report as to how well the Cayman Islands was complying with those standards. FATF has 40 recommendations, and they're accompanied by interpretive notes, which you may see in reference material referred to as INs. Separate to that, FATF has a methodology, and that methodology has distinct criteria by which countries are assessed. So it's an extremely transparent process. Half of the assessment, well, I say half, let's say part of the assessment, relates to technical compliance. And this is a question of how well countries have implemented a framework, whether it's laws, regulations, or in some cases it may be guidance, but that's the technical compliance side. The second side, which is more difficult, is effectiveness. How well are countries using those laws and that framework? So if we take, for example, money laundering, on the technical compliance side, do you have the offence? Do you cover all the relevant predicate categories of offences? And do you have a sufficient sentencing power? But then if you look at the effectiveness, how well are you utilising that in practice? How many prosecutions do you have in line with your risk profile? So in relation to the 5th round methodology, this has been published by FATF in draft form, and it says draft, and it says it's subject to change, and it is on the FATF website. But of course, at the moment, it's only draft until the final version is received. So that's just a little bit of background. And if we look at the background as specific to the Cayman Islands, the CFATF that we just spoke about is one of 9 FATF-style regional bodies. So we have the central FATF, and then we have these 9 regional bodies, one of which is CFATF. CFATF has 24 members, and the Cayman Islands is, of course, a member of CFATF. The Cayman Islands underwent its 3rd round evaluation with that report of November 2007. And then we just discussed some of the details around the 4th round report timing, and that report was published in March 2019. So you can see there the 3rd round, the 4th round, and what we're talking about today is the upcoming 5th round. Now, the Cayman Islands, as a result of that 4th round report, we spoke about the fact that there were those recommended actions. In relation to the technical compliance and the effectiveness, the technical compliance was not the reason that the Cayman Islands was subject to that observation period. It was, in fact, the effectiveness. So how well were the laws being used in practice? I said we had 63, and three remained and were placed on the grey list. Cayman Islands has done really well and addressed another 2, leaving only 1 action remaining now, and that action relates to immediate outcome 7 and the prosecution of money laundering cases in line with the risk profile of the jurisdiction. This is a difficult area for all jurisdictions, and FATF publishes the results of the mutual evaluation reports, and I took those results and put them into a chart form for us to see in relation to IO7. So this is as of this month, the results for immediate outcome 7. So you can see here that a huge number of countries have the lowest rating of a low level of effectiveness. Over 150 have medium or moderate levels of effectiveness, and only less than 50 have ratings of substantial. So this is a difficult area for all jurisdictions, and it's the one remaining action for the Cayman Islands to complete and then to be removed from the grey list.
Okay, so quick question. So again, just so I can understand this chart, so the LE stands for low level of effectiveness, and you're saying there's over 200 countries that have low level of effectiveness in their money laundering regulations or compliance?
Yes, so this immediate outcome 7 relates to money laundering investigations and prosecutions. So these are the results of mutual evaluation assessments of all the different countries that have been assessed thus far.
Okay.
And so we see that over 200 countries received a rating of low on this particular immediate outcome.
Okay. And then, but then other countries, they got a medium, and less than 50 got substantive. Is that, or
substantial? Yes.
Yeah, substantial. Okay. Okay. And what's the current status for Cayman on the gray list? Will it likely be removed anytime soon?
So there were those 3 actions, 2 of which have been addressed, and the remaining one is IO7. The FATF plenary meets 3 times a year. They just met in February of 2023, and the next meeting will be in June 2023. So the Cayman Islands will provide a report for them to review to assess whether the Cayman Islands has met that. If they have met it, then there would be a request for an on-site visit, then there would be an on-site, and then there would be a submission to the plenary after that, seeking removal of the Cayman Islands from the list.
Okay, so we still got some months, it sounds like.
Yes, so the next meeting will be January, where any decision could be taken.
Okay.
So looking more broadly at general effectiveness and compliance with the FATF standards, a review was undertaken by FATF in April 2022. To successfully achieve the 11 immediate outcomes of the FATF-based peer reviews, countries need to make fundamental or major improvements to their money laundering and terrorist financing systems in the next round of mutual evaluations. This can only be achieved if countries redouble their efforts. In this regard, the FATF's peer review process can help apply pressure and incentivize greater progress. So what they recognized there was that it was this area of effectiveness which really needs greater focus and is where countries now need to focus. So what we will see in this 5th round is a greater focus on that area, and that is that second area I spoke about with the 11 immediate outcomes. Another distinction that we're going to see is, whereas we had previously immediate outcome 3 that related to supervision of both financial and non-financial businesses, so that would be, for example, our lawyers, our accountants, they have now been separated, so they will come into 2 distinct areas, and FATF says this will provide a clearer overview of the level of effectiveness of these distinct areas and stronger and more targeted recommendations for improvement. So we'll be able to see more clearly, for example, if a country is strong on the supervision of the financial sector, but less strong in relation to those designated non-financial businesses and professions. The recommendations are to be more results-oriented, focusing on specific actions and timelines to tackle money laundering, terrorist financing, and the financing of weapons of mass destruction. So what we hope to see there is that when countries receive their outcomes and their recommended actions, they are specific and targeted, and countries know exactly what they need to do, because of course the overall idea is that countries will then be able to improve and have better systems to prevent and detect money laundering, terrorist financing, and proliferation financing. Also, the next round of mutual evaluations will be a 6-year cycle, which is significantly shorter than earlier rounds, which have lasted about 10 years on average. So there are some of the key points, generally speaking, and perhaps we could talk a little bit about some of those more specifically. Now, in relation to national risk, we've done an overview of some of the countries. Now, it should be noted here, this is roughly speaking the comparison, so not the specific numbers, but you can see here that countries have done a bit better, particularly in relation to substantially effective. In relation to highly effective, there are 2 countries, and these are Bermuda and the United Kingdom. So let's have a little look at risk and context, Kimberly, if we may. This is going to be an area of increased focus, and it's fundamentally important. And I note that when you were doing your research, you first looked at the national risk assessment, and that really is the bedrock of everything that comes afterwards. So we're going to see an increased focus on risk and context, and when each of the individual immediate outcomes are assessed, then it will go back to what's the risk and context of the country. We've seen increasing focus on beneficial ownership, and FATF has made it clear that their priority is to improve the transparency of beneficial ownership and prevent criminals, the corrupt, and sanctions evaders from hiding their illegal activities and assets behind anonymous shell companies, other businesses, or legal arrangements. So we've already seen FATF revise Recommendation 24, which relates to legal persons, and they are going to publish guidance on that, which is due to come out in March of this year. And we've also seen that there is a requirement to look at the risk associated with foreign companies to which the country is exposed. So we've already seen revisions to Recommendation 24, guidance is to come. And we've now also seen that Recommendation 25 has been revised and agreed, and a guidance document is to be prepared on that as well. So just to bring to everyone's attention that beneficial ownership is of course key and is again going to be a focus in the 5th round.
Now you mentioned that there's going to be some new guidance finalized and published this month. And I take it is that a new interpretive note when you say guidance?
No, so the interpretive note has already been agreed. I think there's going to be guidance in relation to how that is to be dealt with.
One thing I noticed is that in the current interpretive note to Recommendation 24, I think it was paragraph 2, line item C, it states that beneficial ownership information is to be made publicly available. However, I think we're all aware that the EU Court of Justice on the 22nd of November 2022 ruled that the general public's access to information on beneficial ownership constitutes, and I quote, a serious interference with the fundamental rights to respect for private life and to the protection of personal data. So is that ruling driving the revised guidance and a new interpretation note and guidance?
No, so the Recommendation 24 has been ongoing for some time and discussed prior to that, and there was a commitment in relation to the overseas territories, but the Ministry of Financial Services in the Cayman Islands have issued a public statement to say that they are reviewing that court decision very carefully, of course, in terms of what it means for them and what it means in terms of their commitment. So we expect to see further movement in that area.
Okay, so we have another polling question.
Yes.
Yes. So that is, have you conducted a proliferation financing risk assessment for your company, or if you are with the government for your country? So if you can take a few seconds to, and I'll admit, I have never done one. Is this something that you guys help with?
Yes, we do. Both the proliferation financing at the entity level and the country level. Okay.
Great. All right, Tom, if you want to go ahead and close that down, we will. So it looks like I'm in a good company because I've never done one, and 67% have also confirmed that they have never done one. 33% have said that they, yes, thank you very much for. So that's clearly an area where we do need to ramp up our skill set.
Yes, because this is an important upcoming change. So there's been a revision to Recommendation 1 and its accompanying interpretive note, and it requires countries, financial institutions, and designated non-financial businesses and professions, as well as virtual asset service providers, to identify, assess, understand, and mitigate their proliferation financing risks. Now, these risks are specific to the risk of potential breaches, non-implementation, or evasion of the targeted financial sanctions related to proliferation financing, as contained in FATF Recommendation 7. So FATF Recommendation 7 deals with targeted financial sanctions in relation to proliferation financing. And what's now being asked is that countries and entities assess their risk of these being breached, or if they were not implemented, or if they were evaded. Now, FATF has produced helpful guidance on this, and it's important to note this guidance is both for countries as well as entities. So it's not just at the country level, it does specifically refer to private entities conducting these risk assessments. And that's a June 2021 document. And we've also seen proposed revisions to the anti-money laundering regulations in the Cayman Islands. They have been circulated, they're not yet in force, and they also deal with this specific issue of assessing the risk of breach, non-implementation, or evasion of targeted financial sanctions in relation to proliferation financing. So this is an important area for entities as well as countries to be aware of. The Cayman Islands conducted a proliferation financing threat assessment in 2020, and as part of that national risk assessment that we discussed earlier of 2021, there is a specific section dealing with proliferation financing risk. So I would encourage people to look at that if you haven't done so already. And I think that's a useful background, as well as the CIMA guidance notes also contain a section on proliferation financing, which also does refer to proliferation financing risk.
Okay. Yeah, I did print out that FATF guidance on proliferation financing risk assessment and mitigation, and it's about 60 pages. It was pretty, decent read. I haven't read it in its entirety yet, but a quick scan of that and another article I found on proliferation financing, it kind of had me kind of mulling over two things. And one is that there's definitely a difference between proliferation financing and terrorism financing. Is that correct?
Yes.
Yeah. And the other one is that proliferation financing, it seems only related to North Korea and Iran sanctions, and not necessarily requiring compliance officers to assess the risk of, the ingredients for weapons of mass destruction. Am I correct there too?
Yes, so Recommendation 7 deals with the two specific targeted financial sanctions regime in relation to Iran and in relation to North Korea. It's important to note that that doesn't mean that they're the only countries to look out for, because of course there could be other countries used in the process of proliferation financing. But in relation to your question about the wider proliferation financing risk, this is limited to only the risk of the breach, non-implementation, or evasion of those particular targeted financial sanctions. Moving on then to asset recovery. This is another area that countries have found very difficult. And of course, in some ways it is related to immediate outcome 7, because immediate outcome 7 is those investigations and prosecutions, and immediate outcome 8 is the asset recovery, although the asset recovery can be wider than just money laundering. It could be asset recovery, for example, in relation to foreign requests that are coming in for countries to recover those assets. So this is another difficult area, and I will supply with these slides, Kimberly, the figures of the countries. So here we see the comparison, but I'll provide the actual figures for the countries and their ratings. So you can see again that most countries were low. almost as many were moderate, and then a few substantials in there. So again, it's a very difficult area, and it's important to note that this is an area of focus, and FATF has made that clear, the FATF presidency has made that clear, and they will be assessing this and hopefully seeing better results in the 5th round. Countries intercept and recover less than 1% of global illicit financial flows, as we can see from the next slide, and their estimates by the United Nations Office on Drugs and Crime. So FATF has said that improving global asset recovery is one of its priorities. And we just saw in February of last month, there was a learning and development forum on asset targeting and recovery. And we also saw in September of last year the promotion of a joint initiative between FATF and Interpol to promote national policies and actions that prioritize tracing, seizure and confiscation of criminal assets. The idea is to enhance operational cooperation at the national, regional and international levels, and to increase the effective information sharing among public authorities and also within the private sector. So 2 aspects of cooperation and coordination and sharing the information, because as we saw with IO7 and money laundering prosecutions, these are often cross-border, and you need that international cooperation in order to exchange information and ultimately obtain evidence that can be produced in court. So these are areas that are being worked on and that hopefully will be improved upon. And we may also see revisions to Recommendation 4 that deals with confiscation at the domestic level, and Recommendation 38 that deals with confiscation in relation to mutual legal assistance requests.
Okay.
The Cayman Islands is a member of R.4 and in fact currently holds the presidency and hosted the AGM in November. And that is an informal asset recovery network. And such networks are really useful for contacts, for exchanging information, for making sure a request goes to the right person. So these are the kinds of initiatives that countries will work on to try to improve their asset recovery.
Okay, and for those listening in, I was not familiar with ARIN, and it's ARIN, Carib, and that stands for the Asset Recovery Interagency Network for the Caribbean. And I think you said that that was started in 2018, 2017?
2017 it was started. It does have a website of ARIN Carib.
Yeah, ARIN-Carib.org if anybody wants to look at that.
Yes.
Another quick question I have for you, Elizabeth. That FATF, it says Learning and Development Forum on Asset Targeting and Recovery, February 2023. Who attends that? Is that just, I mean, is that regulators, supervisors? Is it just, who's actually going to that?
Yes, it was also law enforcement and prosecutors. And I know that one of the prosecutors from the DPP's office in Cayman, who also deals with international cooperation, was actually in attendance at that event. So I will look forward to hearing all about it.
Oh, okay. So I guess that's just, was that, how long was that? Was that like a week, a day?
I think it was 2 days.
2 days.
I'll check that.
And you talked about some revisions for R.4 and R.38. Do we know when to expect to see those revisions?
No, this is just in relation to the general focus on asset recovery and what can be done about it. And these are the 2 specific recommendations in that regard. So we should keep a lookout for any potential changes to those.
Okay, great, thank you. We have another polling question. And it is, are the RS7 FATF requirements rules-based or risk-based? So we'll quickly see. I think most people are going to get this one. All right, Tom, go ahead and close that one down and show the results. So yeah, 79% say it's risk-based, 21% says it's rules-based. I'll let you tell me which one is it. I'm going to assume risk-based.
The answer, Kimberly, is rules-based, and I think it's a tricky question and it's a difficult area. So in relation to the obligations on targeted financial sanctions and screening those individuals and complying with all the sanctions requirements, this is rules-based, it's not risk-based. The new addition now of Recommendation 1 is to add a risk assessment requirement. That's in addition to those Recommendation 7 requirements, which everyone must comply with. And as we know from the Russian sanctions that have been imposed and that have been circulated in the Cayman Islands, entities are familiar with the process and the procedure. And so in relation to those proliferation financing sanctions, entities must continue to comply with all those obligations. The risk assessment is in addition to those and not instead of those. And the idea is that the risk assessment will also assist, because the sanctions requirements are not only on the individuals who are on the list, but those acting on their behalf. So it's difficult to know who those persons are. And the idea is that by conducting this risk assessment and seeing what your exposure may be, you will be better equipped to be able to identify any potential cases of evasion of the proliferation financing sanctions regime. But it's important to remember that compliance with those targeted financial sanctions remains exactly as it was before, and the risk assessment requirement is additional to those. Thanks, Kimberly. So just a few points to conclude with today. Hopefully we've seen that risk and context is key. The risk must be assessed, understood, and corresponding mitigating measures demonstrated. The assessment of proliferation financing risk is a new requirement. We've seen that there will be a greater focus on effectiveness, how well are the countries implementing the laws and regulations. The mutual evaluations by FATF will commence in 2024. And as I said, whatever year your on-site visit is, that country will be required to provide statistics for the preceding years, which is usually a period of 4 years. And the mutual evaluations by the FSRBs, including CFATF, will commence shortly thereafter. And just to say, which I think goes without saying, detailed and thorough preparation will be essential.
Absolutely, yeah. And for those who don't, the FSRBs, it stands for FATF style regional bodies, and that's like the Caribbean FATF regional body as well. Yeah, and where can, if anybody is looking for their country's risk assessment, including, for anybody in Cayman, who is the big part of our audience today, where do they find, is there a kind of a central database for all the country NRAs, or do you have to go to your regulators? Where do you find those?
So the Cayman Islands National Risk Assessment of 2021 is on our Anti-Money Laundering Unit website, which is amlu.gov.ky.
So can you repeat that?
amlu.gov.ky.
And that's U as in the letter U?
Yes, the Anti-Money Laundering Unit, amlu.gov.ky. And you can also find other risk assessments on that same website. And then we also have sectoral risk assessments conducted by CIMA, and those can be found on CIMA's website.
On CIMA's website, okay. CIMA is the Cayman Islands Monetary Authority. So, and is it kind of similar for each country? Like they'd have to go to their FIU or their regulator? Would they? I mean, I take it this is. I mean, I know Cayman's is pretty public. I mean, are these all pretty public?
Countries are always encouraged to publish as much as they can, even if they have to sanitize some parts. And you can find many national risk assessments that have been published. Most countries have a central agency that's appointed, and they're required to have an agency that's appointed to coordinate risk. So in the Cayman Islands, it's the Anti-Money Laundering Unit. And you will find that or a similar unit in different countries who then have the national risk assessment. And in the Cayman Islands, it's also referred to by other supervisors as well, because of course it affects everyone.
Okay. All right. Well, thank you. Elisabeth, thank you so much for your time. I mean, we did this in record time. I think we covered quite a bit. And thank you for sharing this.
Too fast.
Yeah, and thank you for sharing this information. I know I've learned a lot just in preparation for this and during this broadcast. So again, thank you so much. I'm also looking forward to having you back with us in May to discuss MLRO liability. I know that's a big concern for a lot of people in the MLRO role, and I think that's going to be a very interesting discussion. Also coming up, we're going to be welcoming back John Tobin. He's with the U.S. Homeland Security. He's a special investigator. He's going to be talking about the black market foreign exchange, and that's going to be 5th of April. So do note the date changes. This was previously kind of advertised as going to be, it was going to happen on 29th of March, but we've had to move the date to 5th of April. John gave me some homework, and I'm reading a book by Sam Cooper called Willful Blindness in preparation for that broadcast. And if you haven't read it, for anybody who's interested in joining us, do get it. It is rather frightening, and it's going to change your mindset about a lot of things. I know it's changing mine. I'm also going to be speaking with a few potential guests and some topic ideas, and I'll keep you informed. And Elisabeth's colleague, Justine, she's going to also speak on entity level risk assessments. And I know that is also a big challenge for many compliance officers. And that will also be in May, and that will be a date to be determined. So just again, you keep opening up our emails, and we'll let you know that when you're invited or when those dates are going to be in the registration link. Also, I am going to be in the Channel Islands later this month, and I'm looking forward to meeting a few of you in real life. So if you are interested in booking some time with me or want to grab a coffee, I'd love to meet some of you and hear your views about the challenges you are facing, and so I can explore some solutions for you, or kind of send you in some right directions for people that can help you out. So please do reach out to me if you are in Jersey or Guernsey and the Channel Islands on these dates, 27th through 30th of March. I'd love to meet some people in real life. I'm just now starting to travel again after 3 years. So this is, it's nice to kind of see people again for the first time. Thank you again for joining us today. I also want to thank Thomas Gardner, who operates quietly in the background during these broadcasts, launching the polls and answering some of your questions during the broadcast. I really couldn't do this without him. So thank you very much, Tom. Also, Scott on the Silo support team, who edits the recording and is the one that gets it uploaded on our website. So we will share the recording via email, and we do get it up on our website after about a week. So just that's where you can find all of our old broadcasts, and that's silocompliance.com. Finally, we have a new head of partnerships, James Moore. If anyone is interested in sponsoring a future broadcast of Gray Matters or would like to partner with Silo Compliance System, you can reach out to James directly. If you want to demo Silo, reach out to Tom to get more information. And thank you again for joining us as an audience, and also to you, Elisabeth. For the audience members, I do hope you found today's broadcast informative. I know I did. I do hope you will continue to join us at future broadcasts of AML Gray Matters presented by Silo Compliance Systems. And this is Kimberly Smith, wishing you all the best in your compliance journey.
Anti-money laundering compliance and customer and vendor onboarding involves multiple processes that must be done correctly and by the right people in the most efficient way. The tasks include gathering customer and vendor ID and verification documents, screening against sanctions and politically exposed persons lists, analyzing any reputational risk, periodic monitoring to assess any changes and updating due diligence, and staff training on money laundering, terrorist financing, bribery and corruption awareness and risks, as well as keeping them up to date on your policies and procedures and new regulatory requirements. In addition to the onboarding processes being strictly followed and documented, management must have access to critical compliance metrics and information to steer the company through regulatory waters and mitigate customer and other risks. With Silo Compliance System, these obligations become much more efficient. With Silo, your staff can enter the customer's information and upload due diligence documents and any other documents that you require. Key information entered about your customer automatically calculates a risk score, a calculation using a risk-based approach determined by you at initial implementation of Silo. In addition, if you have screening enabled, when the customer's name is first entered into Silo, the name is checked against sanctions, politically exposed persons list, and adverse media. You'll see results of screening immediately and can review any potential hits right away. And with screening enabled, your customers and vendors are continuously monitored for any sanctions advisories, helping you get ahead of any potential reputational risks. No company is too small to benefit from using Silo. Even if your onboarding processes seem under control today, if one key staff member becomes unavailable or there is any increase in your customer portfolio, compliance with strict onboarding and review processes can quickly overwhelm a small company and put you at risk. Plus, implementing Silo can reduce the need to hire additional staff to manage compliance obligations and reduce your risk of non-compliance regulatory penalties and continued inspections. No one goes through an inspection or audit with great ease, but several users have reported that their inspections went more smoothly and with Silo they had improved outcomes. Reach out to us today to schedule a demo of Silo.